Well, thank you, everyone. We're very excited to be here. We think we have a really interesting panel. I think you just heard some of the issues that we're going to talk about a little bit, just teased in that last question with the opt-outs. And I think the problem that we had, Todd, Denise, myself, and Jeff, who's on the screen. Is Jeff on the screen?
Not yet, but he should be.
Oh, maybe we should give Jeff a minute. Well, let me just not to waste our time. We're going to have someone remote who's an expert to complement our panel. But really, the problem that we had in putting together this presentation is just the size. I mean, it's just a massive, massive area. It's very complex, but also just massive when you talk about the criminal, civil, opt-out litigation in the U.S. It's very well developed. The law is also very well developed and established, but it's evolving. And I think really the elephant in the middle of the room that makes this such a big area is just the high stakes. I mean, these are really high stakes cases for defendants and plaintiffs in the U.S. if you talk about from a damages perspective. I don't think you can really understand this area from the outside unless you understand how the damage laws in the United States work and how they're designed to work. And they're basically designed, if there is an established antitrust violation, the laws are designed to be punitive and not to be compensatory. So that drives a lot of the behavior that comes into these cases, both from the plaintiff side and the defense side. The stakes are really, really high. So we're going to try to go through all this with you today. We have sort of a timeline approach that we're going to do, which I'll explain in a minute. But why don't we just give Jeff one? You're waiting for him? Okay. Well, then we'll just get going. Why don't we start with introductions? We'll introduce Jeff. Denise, ladies first. Go ahead.
Oh, fine. Hi, everybody. It's been nice to be here today and yesterday. My name is Denise Plunkett. I am an antitrust litigation partner at Axinn, Veltrop, and Harkrider. We are about 110 lawyer, mainly antitrust firm in the U.S. We've got 5 offices and probably the largest full-time competition practice in the U.S. With over 70 antitrust lawyers. I've been litigating for about 30 years and do a lot of class actions, although I've had a little taste of the plaintiff side, like both of my co-panelists here, and really looking forward to talking to you about some of the very sprawling litigation that we're seeing lately in particular.
Thank you. Todd?
Hi, thank you. Todd Stenerson from Shearman Sterling. I'm in the Washington, D.C. office. Do all types of litigation on both sides of the V. And just to follow up on what Philip said, to put some numbers on it, right? 4-year statute of limitations in an antitrust case in the United States. If you've got claimed harm of $10 million a year, times 4, that's 40 million. The case takes 3 years to litigate. You get another 30 million, that's 70 million. You treble it automatically, that's 210 million at issue, plus the risk of attorney's fees and costs. And so you get the idea of how quickly these cases, how important they are to all the litigants.
Hello, everyone. I'm Phil Iovieno. I've been practicing for 30 years. I would say the last 25 years, the majority of my practice has been in antitrust, about 75%. I do both plaintiffs and defense. Oh, good, Jeff's here. For 20 years, from 2000 until 2020, I was a partner at Boy, Schiller and Flexner, where I did both plaintiff and defense-sided cases, mostly antitrust. Around 2007, I got into the opt-out space, and that has, in the last 15 or so years, been a really big part of my practice, representing corporate opt-outs, groups of corporate opt-outs in certain cases. In 2021, I, along with a few others, left to join Cadwalader, and I'm currently the co-head of antitrust litigation at Cadwalader. And we have Jeff on the screen. Jeff, we just did a very brief introduction, and why don't you introduce yourself to the audience?
Sure, and happy to be joining all of you remotely from Washington, D.C. I am a managing director at Harkrider Research Group in the economics and damages practice. And like everyone else up on the stage, most of my practice revolves around competition issues with a particular specialty in class certification. So analyzing the economic issues that would frequently arise at that part of class actions.
Great, thanks, Jeff. So the way we've designed this is, what we want to try to do is tease out the main issues. I mean, it's just a massive area. So you'll see, hopefully at the end, you'll get a good sense of, in the United States, how do these cases, how do they come to be? What's the different phases of the cases? So we designed it to do that. At the end, we're going to leave some time for questions. But I would also say, feel free to reach out to us, talk to us after the presentation, or reach out to us by email or phone if you have more questions. Because to say that we're scratching the surface is really the understatement. It's really, we're not doing it justice. You could take each one of the topics we're going to talk about and spend entire panels on them. But we're going to start with a timeline of litigation, and the first piece of that, we're going to try to summarize for you the substantive areas of antitrust where we see the most litigation. And Todd is going to start with Section 2 of the Sherman Act, which is designed for single firm offenses.
Yeah, thanks, Philip. So single firm conduct, right? So non-conspiracy cases is a very hot area. And these are cases where the existence of the conduct that's being challenged is really not in question. Examples are exclusivity provisions, most favored nations clauses, and corporate policies that are incorporated in agreements with suppliers, distributors, and customers. And these cases are industry agnostic. In a given day, I might have a case in healthcare, consumer products, and government contracting, all over single firm conduct. And really the focus of these cases are from the perspective of the consumers in the United States, and is the conduct characterized properly, conduct that lowers prices, increases quality of the products being sold, and gives consumers more choice. As you might imagine, the plaintiffs on the other side of that would take the view that the conduct that's being challenged does not lower price, does not increase quality, and does not increase choice. And these cases, because the conduct is not in question, there's I think, again, from a defense perspective, an overemphasis on the conduct itself or the agreement that it's embodied in. And these cases are heavily then litigated over markets and the need to show actual harm and injury and then damages. So there's a lot of fact inquiry and investigation over really whether these cases cause any real injury. Because again, the fundamental part of the conduct cases is there's really not a dispute that it's occurred.
Totally agree. And Denise is going to cover multi-firm offenses, so Section 1 of the Sherman Act. So how does that compare?
Sure. So Section 1 claim, typically known as a price-fixing claim, which your typical cartel claim would be your standard Section 1 claim. Anything involving a contract, combination, or conspiracy that results in an unreasonable restraint of supply. But obviously these conspiracy claims or contract claims can run the gamut, not just from traditional price fixing, what you might think of going on in a smoke-filled room, as we all say, but things like bid rigging cases between buyers of a certain product or input, index manipulation cases. We've been seeing a lot of those, and supply restraint conspiracies, which both Phil and I have been pretty actively involved in those kinds of cases recently, where it's alleged that an entire industry is conspiring to lower supply in an effort to boost prices, and also group boycott cases. All of those are kinds of cases that would fall under Section 1. Depending on the kind of case, it could be a per se violation, or it could be analyzed under the rule of reason. Obviously, rule of reason cases are more complex, but even a per se violation in these cases can be, difficult for plaintiffs to prove if they don't have, a written agreement in evidence to focus on. And I think the thing that we have really seen is that these kinds of industry-wide cases are really proliferating. So there will be alleged conduct within a certain industry. Cases are brought. They can start in a variety of ways. They can start with private plaintiffs, suspecting as a result of something like a price spike without a corresponding price drop when one might expect it to happen. To bring cases and bringing them sometimes against very large industries, not your typical small oligopoly of 4 or 5 players, but maybe, a couple dozen defendants that are alleged to have worked together to restrain supply. But they also are leading, not just these big cases against the whole industry, but also multi-layered claims, meaning, classes, right? Direct purchasers will bring, cases on behalf of, the whole class of direct purchasers. And we're also seeing more and more indirect and sometimes doubly indirect purchasers bring claims, antitrust claims under state law or in repealer states, where, purchasers from the direct purchasers or even end users or consumers are suing as a class, even if they aren't direct purchasers. So you can have a rather sprawling litigation nationwide for virtually every level of purchaser brought through the class mechanism. And sometimes these cases will spawn government investigations. Sometimes they'll follow on to government investigations. So it used to be, years ago, that until you saw, the DOJ go after, an industry or a big player in an industry, and potentially with criminal investigations or indictments, then you would quickly see the follow-on private litigation would really jump on the coattails of a government investigation or proceeding and really just try and scoop up behind the government. But now what we're seeing more and more is the private plaintiffs bar leading the way. And then we'll get more into detail on this, but then what then can result is major opt-outs. And I know it's the last thing that the last panel just talked about, but it can be, dozens, if not hundreds of opt-out plaintiffs, often not just individuals opting out of class actions like you would see on these rare occasions with consumers, but the biggest companies in America opting out and bringing their own direct action lawsuit. Lots of procedural mechanisms. Sometimes these different claims are consolidated in one court. Sometimes they're just coordinated in one court. A lot of procedural complexities even at the very outset of a case. And one thing to remember is these cases can be filed and the piling on can continue for a number of years. Sometimes people opt out very early, and sometimes they're not opting out until they're notified through class cert that that's officially their deadline to do so. And then some big plaintiffs just are quietly bringing their own one-on-one actions in arbitration or otherwise. So this is the kind of sprawling litigation that we're seeing in multiple fora that then also can be accompanied by individual state attorneys general actions at the state level on behalf of their citizens as purchasers or as the state itself as a purchaser, whether or not they would also actually be represented within the classes that have already been pled. So you can be, and this is not uncommon, be faced with litigation against an entire industry that is going on in quite a few different jurisdictions with both individual and class claims, and then also sometimes private dispute resolution.
Yeah. Look, I think that it's a lot, but it's a really accurate, from both what Todd and Denise said, it's a really accurate thumbnail of just how complicated it is. And I think, if we could serve you in one way, it would be to give you a sense of what are the things that are driving the behavior in the United States. And one of them is the damages. The damage laws in the United States are meant to be punitive. So you have a very entrepreneurial plaintiff's class action bar, and the upside to them in some of these cases is quite high. Like Denise said, the first case where there was a lot of opt-outs was in 2002, this vitamins case, and then since then, if you move forward, the LCD and LCD price fixing, CRT, all these cases in the electronics industry, and now there's a lot of cases in the protein industry and others. But back with vitamins and the electronics cases, those were cases that were led by the government. The DOJ found established price fixing and brought a very aggressive criminal prosecution that was picked up in other areas of the world, including here in the EU, and the class actions followed. You're not seeing that as much now. It still happens, but you're seeing independent class actions that are driven by the plaintiff's bar, some of which are meritorious and some of which aren't. So we're going to walk through the litigation stages with you. I think we've sort of covered the initiation pretty well, which is these class actions get filed, There's a mechanism in the United States called the multi-district litigation panel. So when these cases get filed all over the country, they consolidate them in one court for pretrial. At that point also, there'll be competing class action firms looking to become lead counsel. It'll be a big fight in the good cases. Eventually, the court that gets the MDL will decide who will be lead counsel, and that will be the class action that goes forward, okay? At this point, I do a lot of opt-out work. There's not typically any opt-out activity right now. If you're a big purchaser in a class, the wise thing to do is to pay attention. And we'll talk some more about, you know, how I advise opt-outs and what opt-outs do in the states and what they don't do. But at the end of the day, at this stage, it's really the plaintiff class action that gets going. From the defense side, I'm going to turn it over to Jeff in a second. You know, it's very common to have a motion to dismiss filed, trying to get the whole case knocked out. Those are very typically denied. The law in the United States, putting aside the damage law, if there's one other thing you could take away is it's really designed to have these cases resolved at trial. It's part of the whole civil system, which is designed to have cases resolved at trial. There's mechanisms to have the cases thrown out before trial, which we're going to talk about. The first one is a motion to dismiss. Very hard to get. Most cases, even the ones that are sort of, you know, iffy, get through the motion to dismiss stage. So from the defendant's standpoint, the defendants will typically make a motion to dismiss. But the really sophisticated defendants, when they get hit with one of these cases, will realize that these cases are very high stakes, and they'll get going on the heart of their case right away, which is the expert work. The expert work, when you get to trial, is critical. These cases, and if you go back and look at my experience, but if you look at other cases that were tried, these cases at trial rise and fall with the quality of the expert work on both sides. And so the best, I think, strategies from the defendant's standpoint are ones that retain experts early and do their analysis early and let that expert analysis drive what they do in fact discovery. So Jeff, why don't you talk a little bit about what you've done at this early stage as an expert?
Sure. Just to go back to something that you mentioned, that ultimately these cases are going to be resolved at trial. And so a big aspect of the class certification process is ensuring that when you aggregate these hundreds or thousands or even millions of claims, you're going to have consistency in those claims such that it makes sense to try them in one trial. And so frequently
So that's, I think, a really good summary of the early stages of the case. The next stage, which is really the meat of the case, and what I would say is really where most cases are won or lost, the preparation of the case, is the fact discovery, the expert discovery, and the class certification stage. So Denise is going to start with the fact discovery, Todd's going to do class cert, and Jeff and I will just clean up a little bit on the experts, although we've really sort of covered the experts, so go ahead.
Yeah, so fact discovery might be what you most negatively associate with the U.S. discovery process, because as you know, fact discovery is expensive, it's massive, sprawling, intrusive, disruptive to clients. And just in this day and age, with the advent of email as well as data and electronically stored information, it's a behemoth task in an antitrust case or class action in particular. But you know, facts matter, as someone just said on the last panel, and we say so often in this job, fact discovery is vital. If you're trying to prove an unwritten agreement amongst everyone in an industry, for example, or even a small group of major manufacturers or suppliers, people, besides looking at the data and trying to understand pricing behavior, people are looking for evidence of the agreement. So even if the agreement was never written down, there are other indicia of agreement that people will be looking for in their documents. And of course, in particular in a rule of reason case, defendants are going through their own documents looking for their business justifications that show they were doing everything in their unilateral, rational self-interest. Contemporaneous business-making documentation, for example. So the amount of discovery that is produced in these cases is massive. Just trying to figure out where to find it can be a multi-month undertaking. Your typical discovery rules that limit depositions in federal court to 10 per side and 1 7-hour day per deposition. I mean, they're just not going to apply in a case that might have, you know, 1 or 2 dozen defendants and who have nationwide operations. And let's say you're just talking about a bid rigging conspiracy or supply-related conspiracy. You're getting down, it's not just, you know, people want everything from the highest levels of the company, of course, to see what the executives were saying, but they want to know what the mid-level people were doing and communicating to each other in connection with their daily decisions, supply planning and the like. So on both document side, custodian side, and everything that your experts need that's beyond just sales data and pricing data, it really can be a massive undertaking, and not just for plaintiffs who want everything, and then defendants who are trying to limit things, I'll say reasonably, but you know, no one's ever going to be happy with how many custodians you agree on or that a magistrate judge orders you to, you know, per party do searches of. And in class actions, these discovery obligations are pretty one-sided. It's mostly, you know, the class representatives won't have a lot. There's class cert issues, you might get some discovery from class reps on. But now that we have these opt-outs, and you know, it's completely common for major companies in America to be going on the offensive on the plaintiff side, it becomes more of a two-way discovery street. Because when you actually have a, you know, Fortune 50 or 500 company who's doing the buying, they're typically sophisticated players. They have massive amounts of data. They have their own documents that are often the mirror image of what's going on the defendant side. So it's a long way of saying that discovery takes years and can cost millions. And that's just the tip of the iceberg. You still have, you know, just once you get the documents, written discovery out the door, there will be depositions of potentially dozens, if not hundreds of people. And then you get to experts, which is just phase 2 of that rather massive process.
Yeah, listen, I think the fact discovery is critical for the defendants. It's critical for the plaintiffs with these high stakes cases. And then from the defendant standpoint, the next real piece of the puzzle that you want to deal with is, and try to get these class actions sidetracked, is class certification. So we'll deal with that next, Todd.
Yeah, no, that's exactly right. Class cert is the time when a smart, well-executed discovery plan is tested. Right, I can't emphasize enough and agree with the panelists said, facts are very, very important. the discovery of industry participants, right? Again, dozens to hundreds of subpoenas to third parties to create that record, because everybody knows really what the battle is on class cert at the very highest level. The plaintiff argues that, rising tide raises all boats and prices go up. Defendants argue that everything's individualized impact, if there's even any impact at all. But those are the two goalposts, and where you come out in a particular case is going to turn on the facts and the presentation of those facts. And that's where the investment in the litigation strategy can pay off. And it is time intensive, but it can be successful, because class cert in the United States, I think, is hard. I think it should be hard, but it's going to be the outcome of these well-executed plans. And kind of going back to what we talked about before, Denise mentions conspiracy cases. If you're trying to prove whether an agreement existed is one thing, but on class cert, if you're back to the single firm conduct, where the conduct, again, is not really in question, you're then fighting on these injury aspects and harm to a well-defined market, which, again, turns on the facts, and I think that's where the experts now come in.
Listen, I mean, so now we're through the case initiation, we're through fact discovery, expert discovery, class certification. In many of these cases now, you may be 4 or 5 years in, and lots of work, lots of effort. And one thing on class cert that you have to understand, which is a problem for defendants now with this proliferation of opt-out litigation, which is if they defeat the class certification, they do not defeat the case, because the opt-outs have obviously opted out. So that does not end the case for the defendants. It's still critical. But the cases still go forward, which is sort of my point that I made at the beginning, which is you have to look at these cases. If you're representing a defendant from day one, you got to say, how am I going to try this case effectively? Because that's probably where it's ending up. And you need to have trial lawyers, and you need to have experts who know how to do trials. And that's what we're going to turn to now is trials, which is the next section. There's we have summary judgment in trials. You have a chance after all the discovery's done to make a summary judgment motion, which basically says, listen, all those facts that they discovered, under no circumstance can they prove an offense. The law is very tilted towards the plaintiffs in this area, not just in antitrust cases, in all cases. And basically, every inference is drawn from those facts in the light most favorable to the plaintiffs. So it's very hard to get a case kicked out on summary judgment. Defendants have more success narrowing cases, getting rid of some claims that may be, sort of add-ons. But getting a whole case kicked on summary judgment, while not impossible, is a home run. And so we're going to turn to trial, but go ahead.
Yeah, on that point, though, I think that both summary judgment and class certification is a place where both sides will look at the fact record that's been developed and say, is there a negotiated resolution to be had here? And are we going to get off the litigation train and resolve it, or are we going to, as Phil said, go straight to trial?
Yeah, I'll chime in on that. They're two big inflection points for settlements. I would say that if you just look like overall, like just industry-wide, meaning the legal industry, class cert and summary judgment just seem to be getting more difficult to get an entire case out, as Phil said. Not that you can't do it or you can't substantially narrow a case, but I think with the massive amount of discovery that people are able to do, plaintiffs are more easily able to come up with like something that a reasonable juror could find is, in favor of the plaintiffs for those stages. And I think another atmospheric issue that you have in the US, which is that, especially by the time you get to summary judgment, sometimes you are so far into a case, although judges, they certainly look at it, they have a gatekeeping function, and they don't want to waste the jury's time with what will be a non-meritorious case. But on the other hand, when you've had a case that's been going through fact and expert discovery for 5, 6, or 7 years, and you get to summary judgment and you also have a looming trial date, just atmospherically, a lot of judges are ready to just let the jury decide by then. So I think more and more cases are driving towards trial for a large portion of the defendant group.
Yeah, and we want to talk about trial, and Todd's going to take the lead. I will just say from my perspective, trial is everything in these cases. When young lawyers come to me and they say they're really interested in antitrust law, antitrust litigation, whether they want to be on the plaintiff side or the defense side, and they ask for advice about what to do, I don't tell them to study economics or learn the law any better than they already know it. I tell them to go out and get trial skills, Because at the end of the day, that's what drives results in these cases for defendants. It's what drives results for plaintiffs. These cases, when they go to trial, it's not uncommon for them to go to trial for 4 weeks to, from 1 to 3 months. We just had in one of our cases, we weren't involved in the trial, but it's a case we're involved in. The trial went 5 weeks. That's not uncommon. So you need really hardy trial skills. And at the end of the day, a lot of these cases are resolved by trial, or they're effectively settled by preparation for trial. Defendants can get better settlements if they really have prepared the case well for trial and they're ready to try it, and same thing with the plaintiffs. If the defendant really believes the plaintiff's counsel knows what they're doing and is able to try an effective case, which is a hard skill to have, that will drive better settlements on the plaintiff side. So go ahead, Todd.
Yeah, no, and I'm a big fan that, trials are about evidence, evidence, evidence. And so it goes back to the fact discovery that you've been doing for years. Have you been setting it up for how it's going to present at trial and in a courtroom? I think 2 things to point out. You may have a trial that's a month, 6 weeks, so you're going to have dozens of witnesses. It's it's easy to forget how long it takes to get live testimony out in a courtroom, and frankly, how boring it can be. So, right, like understanding what you're trying to accomplish with crisp examination, and you've got arguing over exhibit lists with 5,000 exhibits per party. You get to trial, you maybe use 50. So really understanding what you want to present in a persuasive way is so critical from the thematic point of view, no matter what side you're on. And then from a strategic point of view, I think one of the most critical parts of trial prep are motions in limine. And these are issues that are even ones that you may have lost on summary judgment or you've got pending on Daubert. A lot of times courts won't rule on summary judgment or Daubert before your final pretrial order is due and before your motions in limine are due. And so taking that vehicle and explaining to the judge why certain pieces of evidence are critical or exclusionary for your case, I just can't emphasize enough. We had a case in Las Vegas several years ago. We had prepared a bunch of motions in limine. We didn't know what the page limit was going to be. The judge, I think about 3 days before they were due, said 5-page maximum, you get 15. So, we had to retool everything, but the ability to distill, it was actually a huge benefit for us because having our arguments laid out and then having to refine them into 5 pages or less allowed the judge to rule on them all in a very effective way. We didn't win them all, but I think we got the better part of it. But that thought process of just how that's going to present, I think, is super critical. And then again, just how boring it is. And I've both been in the trials and I've watched them, and I can't emphasize enough how quickly to get in and out. We had a trial in front of a judge last summer, and she gave each side 6 hours. And when we heard that, we're like, how are we going to do this in 6 hours? It was a merger case. But it happened, and we got to the point, and it's much more effective to be short. So I'll stop.
Yeah, no, when I was at Boies Schiller, David Boies is probably one of the best known, most successful trial lawyers in the antitrust space. And really the skill of value that he taught everyone who worked with him, and really is the skill of value, is these cases are incredibly complex factually. From an expert standpoint, the skill of value is the lawyer can take the complex and make it simple for the jury to understand. Sounds easy, but it's quite hard. Jeff, we have about a minute left in the section. Do you have anything to? Yeah, go ahead. Do you have anything to add, Jeff?
Yeah, just to follow up on that. Yeah, from the expert perspective, and this is really following up on your comment, that when you're working with your experts, you have to ensure that they're able to take complex economic theories or complex econometric analyses and present them in a way that an unsophisticated jury can understand. And by unsophisticated there, I don't mean to be negative or critical, but it's highly unlikely that you'll get a jury of economists who are skilled in statistics. And so how do you take something as complex as a regression analysis and present it in a way that just a normal person can understand? And that's, that falls both on the expert as well as on the attorney. The attorney asking the right questions, but also finding a way for the expert to conceptualize some of these more complex ideas. And so, I know my firm, for instance, always has an interview question, even for entry-level staff. One of our standard questions is, how would you explain the concept of a regression to a jury? And I think the answer to that question is very telling of, do you have an innate ability to take a complex issue and simplify it?
Yeah. Just to follow on that, they're generalist judges in the United States. So it applies to busy judges. Simple and clear. It wins over confused and complex every time.
Every time. So we have about 10 minutes left. The last two segments, I think, are really the meat of what we want to do. One is the practical considerations on single-firm and multi-firm offenses. Jeff and I are going to handle opt-outs, and then we have some case studies at the end that I think will hopefully bring a lot of this to real life for you. So why don't, Todd, you start with the single firm?
Yeah, with single firm, I think the key there is you're normally a standalone defendant. So you're a single defendant, you're developing your strategy all on your own, but you also are exposed to the liability. So that's really the key. You have control, but you have more exposure. And that I think is a really important aspect of the single firm cases as opposed to the multi-firm cases, which creates a whole nother dynamic, which Denise is going to tell us about.
Yeah, I mean, as I alluded to in the opening remarks, the multi-defendant cases can be quite complicated, and you can have really not similarly situated defendants. Just picture, industry players that are alleged to have conspired together, ranging from sort of small companies, local regional companies, to sprawling international companies. And you've got joint and several liabilities. So you're all accused of being in some kind of conspiracy together, but there's joint and several liability, and in the US what that means is, one defendant is responsible for the entirety of the damages awarded. It's not divided up necessarily by defendant, and there's no right of contribution. So plaintiffs can go after just, let's say, the biggest pocket or someone else to collect every dollar of those damages that are awarded, which have been automatically trebled by the court. If you lose, there are treble damages. So, first of all, there's always like the practical consideration of, well, you've got, 20 defendants on one side of the courtroom. How do you coordinate as a practical matter? Do you enter into a joint defense arrangement? If it's a conspiracy case, do you want to be in a joint defense arrangement, or do you want to control your own destiny? But if you do that, can you share, what expert expenses can you share? How do you cooperate in terms of, putting on common defenses? There will be common interests. So these can be really complicated considerations and expensive considerations right at the start of a case. And you also have to think about, everyone's got their own unique defenses, right? Their own factual story to tell, why they made certain decisions, why that shows they weren't in a conspiratorial agreement. And people will have very different views, whether you're in a JDG or not, as to the best strategy for convincing a jury that you weren't all in it together, or how to show that certain evidence doesn't mean what plaintiffs will say. You're gonna have a lot of big egos in the room, right? Can you imagine, law firms for 20 different defendants? Even where do you sit? When we were just getting close to trial in our case, as of July, we had a September trial date, there were still 21 defendants in the case as of July. And I think I'm just gonna harken back to something that Todd said. The case winnowed down to a single defendant who actually went to trial. And a few people got out at summary judgment in July, and a few more people settled. And then there were more settlements. It's not because people were scared to try the case, but there were rulings, like even on summary judgment, people were still in the case, but you could read the tea leaves of the readings for some defenses versus others. And so then when you go into your motions in limine, and you're breaking real ground in some areas of the evidence that's going to be in front of the jury. Those are all giving opportunities for people to, evaluate that cost-benefit decision of being at trial. But when we were faced with the idea of a trial of, more than a dozen defendants, and the judge said, the most I'm ever going to give you is 3 months. And then he said, okay, well, maybe I'll have to give you 4 months. And we kept dividing up hundreds of hours per party, and it wasn't very much. But then as people dropped out, you know, the court was still shrinking. But even down to one defendant at trial, you know, the court gave them, I think, 2 months to try the case. And then you start thinking, how can I, this one defendant, or how can the plaintiffs put a jury through that? 2 months of listening to this stuff. There's no industry that's interesting enough to keep a jury's interest for that long. And juries tend to decide, you know, roughly in their head pretty early in a case. So then you're going to, you know, end up with, you know, days of expert testimony, and you've taken hundreds of depositions that you want to use. But then in the end, the winnowing down for trial, especially in a multi-firm case, there's a lot of trade-offs to be made and just a lot of strategic decisions that go into, you know, deciding what is that courtroom going to look like. And then courts also have the decision to make, sometimes in these kinds of cases, who gets to try the case first. You're not going to try a case with 3 classes and 150 opt-outs in one trial. You literally can't get the lawyers in the room for that, right? So courts will often they'll say, you know, you're going first, or they'll pick a bellwether set of plaintiffs to go first, which can then in turn drive how later trials come out. But that's just showing, again, on the practical side, all the kinds of decisions that go into being made as to when we finally get to trial, what does that even mean in these multi-defendant cases?
So look, on the opt-outs, I did a presentation like this not too long ago that was 2 hours, and we're down to 4 minutes here. So I do want to give you some sense, though, because I can tell that there's a lot of interest in opt-outs. What does it mean for Europe? What is it going on in the US? Let me see if I can just give you a real thumbnail. If you go back in 2002, was the first case in the United States where there were significant opt-outs. That was the vitamins case. I think there was about 10 opt-outs. I don't know what percentage of the market. Then in the LCD case, which was first filed in 2007, there was 38 opt-outs, many of them were big. I had a group of 12 companies that opted out. Roughly maybe 40% of the market opted out of LCD, and similar behavior in these other electronics cases. Now in the protein cases, the chicken case, for instance, there's 180 opt-outs. I don't know the percentage of the market, but it's well north of 50%. Billions of dollars of damages have opted out. So this is going on, and what's happening, what's driving this is my perspective, which is there's certain things that are not disputed. You really can't dispute, first of all, that class actions are not designed to really serve large purchasers. They're designed to consolidate lots of small claims and represent them well. A large purchaser generally is not well served in a class. It also really can't be disputed. History shows it, my experience has shown it. Companies that opt out do a lot better from a recovery standpoint than had they stayed in the class. If I don't get my company a lot more than they would have gotten had they stayed in the class, I'm really not doing my job. You know, in the LCD case, which was a really historic case from a liability perspective, my clients in my group got between 5 and 9 times more than they would have gotten had they stayed in the class, depending on their claims. However, and this is the point that's all sort of lead up to this, which is 1 + 1 doesn't equal 2 here. It's not, okay, if you opt out, you get more money, everybody should opt out. I think really the best companies and the best lawyers who are advising the companies look at the opt-out space as being super individualized. And you have to advise these companies are not used to being on the plaintiff side of the V. Many times they have to sue their suppliers. Sometimes they feel pressure because their competitors have opted out. What does that mean for them? So you have to go through a very individualized approach with each one of the clients. And I'll give you just one quick example of how it can play out. In the LCD case, I told you I had 12 companies opted out and filed. We also represented one of the largest OEM, one of the largest computer OEMs in the country. We represented them for about 2 years, and then they decided, we were advising them, and they decided what we're going to do is we're going to opt out of the class, but we're not going to file. And they did a series of private settlements. And we also represented 3 other companies, 2 of whom were large, who, despite having large claims, decided to stay in the class. I think at the end of the day, that's the process that's the best process from an opt-out standpoint, is really making sure each company that opts out does it for the right reasons, has a very clear business reason, understands all the different factors. And like I said, I did a 2-hour presentation where I got into all the things you look at. We can't do that here. But I'm just leaving you with this, my overall perspective, which is it's not 1 + 1 = 2. You really, because you don't want to get these companies into opt-out litigation, moving towards trial against their suppliers if they haven't really gone through all the thought process.
Yeah, just real quick on that. Opting out is not a guaranteed victory.
No.
Right? I mean, one thing from the perspective of a defendant, when you've got a single opt-out, is you can focus and hone in on, again, the lack of harm, the lack of injury, the lack of damage. And so it's one thing to opt out of a case that has an underlying criminal price-fixing plea. It's quite another to opt out of the conduct cases where, as a single plaintiff, you have the burden of carrying that water by yourself. And a lot of times plaintiffs can hide in the complexity of a class to avoid some of those hard issues. And I think if you're an opt-out, that's part of this decision-making process that one needs to go through.
And that dovetails with what I said. Like, when you opt out, you have to be all in because it's your case. There's no hiding. So it's not like, oh, let me see if I can just get some higher settlements. I make sure my clients who make the business decision to opt out do it thoughtfully and are prepared to go through trial. If not, I advise them not to opt out. Jeff, we're almost at the end here. Do you have anything to add? Because I know you do a lot of work with opt-outs.
Sure. When I am counseling clients on opting out, one of the first things we look at is settlement and the potential risks from settlement. That it's not uncommon for class cases to settle at some percentage of the overall value of the claims. And so particularly if you are one of the largest purchasers and you have one of the largest claims, I think this is consistent with what everyone else has said, that you are likely to take a significant haircut on that claim, and you might very well do better pursuing that case individually. But one of the other things that I look at, and this comes up a lot in market manipulation cases, is will defendants try to turn some of the conduct around and blame plaintiffs for it? That it's not uncommon in some of these cases for the defendants to say, well, the plaintiffs were engaged in the exact same conduct that we were, or our supposedly manipulative conduct was only in response to what we were observing the plaintiffs doing in the marketplace. And so oftentimes there might be, with respect to some of the largest plaintiffs, a very specific narrative that relates to that plaintiff. And it's oftentimes not clear that class counsel would do a good job of presenting that story because there are so many different plaintiffs. The story of any individual plaintiff may get a bit muddled in a way that an individual plaintiff would prefer not to see happen.
Yeah. So listen, I think, we're at the end, and you can see it's just a massive area. Single firm, multi-firm, opt-outs. This was not our charge, but funding is now very prevalent in the States, and that's added a whole different element to this area. But I would just end with where I sort of started, which is you have to understand what's driving this litigation. It's the damages laws are really very punitive, and they create huge upside for plaintiffs to file lots of cases, good cases, and many which are, quite frankly, not very good. And also the whole notion of trial and how the system is designed to resolve cases at trial. And you put those two things together and you see sort of why this is probably the most massive area of litigation in the United States. This and securities is the most, but I frankly think the antitrust world, with the opt-outs now, is getting to be more complex and more multifaceted, but that's just my view. But again, if you have any questions, we'll be around. Feel free to ask us or email us or call us. It's been a pleasure. Thank you.
Thank you.